Good morning to everyone.
Good morning, Judge.
Court will note the appearance of Mr. Schaefer on behalf of the plaintiff, Ms. Greenlee-Core on behalf of the defendant. We have two motions. The defendant's motion to hold plaintiff in contempt for make-up parenting time, suspending her parenting time and to enforce the order, and plaintiff's motion for change of custody and parenting time. I've read all the pleadings, so you don't need to rehash those. If there's anything else, Ms. Greenlee-Core, you can start with your motion as it was filed first.
Thank you, Your Honor. This morning we're here. This court has seen this case certainly multiple times in the last couple of months, and so this court is certainly apprised of what's going on. To date, mom is still withheld this minor child. At this point, we're at 28 overnights that father has missed since July 28th. At this point in time, the child has been completely alienated from father. We're asking that this court currently suspend mother's parenting time until father's parenting time has been made up in the amount of 28 days. That mother immediately be ordered to return this minor child today. I would note that this child, as far as we can tell, is not attending school this year. This child was ordered to attend Allegan Public Schools. This child certainly isn't in Allegan. My client made some phone calls to schools around Miss Bailey, and the child's not enrolled there. We don't know where this child's attending school. To remind this court, this child was kept out of school for 3 weeks when she initially took temporary care of this minor child back in May. And this child has now missed the first 2 weeks of school. It's completely inappropriate, completely unacceptable. Mother has violated this court's orders. She's flaunted this court orders and basically has done whatever she wants. At this point, she should be held in contempt of court. We're asking that she be held in civil contempt. She cover my client's attorney fees and costs. My client be awarded make-up parenting time, mother's parenting time be suspended, and that this child be returned immediately at a police station today. Additionally, as far as the motion to change custody and or parenting time, there has been no change in circumstances whatsoever outside of what mother herself has done. So we believe that this motion to change custody and or parenting time should be completely dismissed. There's no cause to move forward. There's been no change in circumstances, except that mother has now violated a court order. So we're asking that be completely dismissed at this point. Thank you, Your Honor.
Thank you. Mr. Schaefer.
Please call, Your Honor. There's been an answer filed to the motion of contempt and a motion to change custody. And as indicated in those answers and pleadings, the difficulty that my client has arisen is she's got almost a 14-year-old who will not go back to his father because he has disclosed physical abuse from him over a period of time, which came to light at the time that the child was to be turned over pursuant to the order of this court. She is not physically able to return the child because of that. I think it is important that if in fact that which has been disclosed to my client of the amount of abuse that the child has received from his father and his fear of going back to his father because of that pending abuse, there needs to be an intercession by either an in-camera review with the court to make a determination in that regard. But my client has not willingly violated this order. She has had the child ready. He would not go. She could not make him go, and he refused to go. There needs to be an evidentiary hearing to ferret out that circumstance. Regardless of the court order, if a 14-year-old is not going to be willing to go back to his father, that is problematical. I understand that, and perhaps if the court is going to enforce that order, there's sanctions against the child for not following the order. But I think the court needs to know through an evidentiary hearing, either in camera interview with the child or in open court, to determine what the circumstances are going. If in fact what he is relating to his mother is accurate, he should not be placed back into that abusive situation. And I think the court needs to intercede in that regard. Thank you.
Mr. Schaefer, has it been referred to CPS?
It's been referred to the police department. A phone call was made and report was to the police department in that regard, and I don't know what the status of that investigation is.
Okay. Well, the court in this matter does note, I do believe that there's been sufficient proper cause or change in circumstances to warrant an evidentiary hearing pursuant to Vadvarka. So the court will schedule that for evidentiary hearing. Likewise, the court will schedule the issue of the contempt and the remedies in that regard. However, the court will state to Ms. Bailey, it's your responsibility to return the child, and the court will order that the child be returned no later than 5:00 p.m. on September 13, 2023. If the child is not returned on that date and by that time, Ms. Bailey, you need to surrender yourself to the Calhoun County Sheriff Department, where you will remain incarcerated until such time as the child is turned over to the plaintiff in this matter, or to the defendant in this matter. So it's your responsibility. You make sure that it happens, or otherwise you will be incarcerated until such time as it does. So I will ask, I guess, Mr. Schaefer, that you would prepare the order referring the matters to for an evidentiary hearing, and as well that your client has to turn the child over or remain incarcerated.
Just for clarification, 5:00 on the 13th, turn over the child at what location?
Where did they have an exchange point that they were at, or was it always at the
There was
defendant's
no
home?
exchange point. There was no exchange point.
Well, then what we'll do is have her, she has to turn the child over at the defendant's home.
Okay, thank you.
Okay, thank you.
Your Honor, additionally, could we make sure that there is an order in place that Ms. Bailey is taking this minor child to school in Allegan per the current court order as well?
Well, if it's a current court order, she has to comply with the court order. So
Thank you.
court will end this matter at 9:09 a.m. You're free to go.
Good
Have a
morning
good
to
day,
everyone.
everyone.
Morning,
Thank
Judge.
The court will note the
Morning.
appearance of Ms. Podolsky on behalf of the plaintiff and Ms. Smith on behalf of the defendant. This matter is before the court on the defendant's objection to the referee recommendation. Ms. Podolsky.
Thank you, Your Honor. The defendant in this matter, back on June 23rd, 2023, filed a pro per motion to modify custody, parenting time, and child support. That hearing was held before referee Mark Croteau on July 25th, wherein the motion was denied with the exception of the child support issue, which was set for an evidentiary hearing. The next day, July 26th, referee Croteau entered an order denying the motion as it pertained to custody and parenting time, citing that proper cause and change in circumstance did not exist to change custody and parenting time, and therefore the motion was being denied. That same day, July 26, 2023, the defendant, being unhappy with the referee's ruling, filed yet another motion pro per, this time to modify parenting time, despite having been told not 24 hours before that his motion was being denied. Referee Croteau also heard that motion. He heard that on August 8th, 2023. At that time, he did set a hearing as to parenting time. He stated that because there were photos attached to the motion and because the defendant was pro per, he was going to give him some leeway. However, the court should not be considering photographs or other evidence that are attached to motions, as those are not exhibits, to be properly seen or heard by the court, as proper foundation has not been laid. Further, the defendant himself said he attached them to his first motion. Second, the court rules do not state anywhere that pro per litigants are given any leeway based on their pro per status. The defendant failed to meet his burden in his first motion. He did not like what he heard on July 25th by the referee. He filed the exact same motion on July 26th, citing the same arguments that he had in his written and oral arguments in the first motion. By allowing this to continue, we're setting a slippery slope, Your Honor, to allow litigants to just continuously file motions within 24 hours of hearings when they don't like the answer. The proper way to have gone about it would have been to file a motion for reconsideration or an objection to the referee's order after the first motion. So we're asking this court to deny or overrule the referee's ruling on that second motion and cancel the hearing as it relates to parenting time.
Thank you. Ms. Smith, response.
Yes, Your Honor. As to the photos that were attached, defendant stated that he was told by the referee that the referee did not receive the first photos that he attached to his first motion. And that is why the referee considered the photos attached for the second motion. Also, the same arguments he argued simply because he did not know, being improper, he did not know about arguing the same facts in two separate motions, Your Honor.
Okay.
Nothing further.
Okay, thank you. Well, the court does note that, again, the timing, there was a motion hearing before the referee on July 25th, 2023. It did encompass, if you would, the change in parenting time. It was denied on that date. Then again, as Ms. Podolsky states, less than 24 hours later, he files another motion on July 26th, 2023 for the same issue. References that in fact it has the same information, et cetera. And the court is not going to, again, support repetitive and multiple motions just because the person's not satisfied with the results. The court does agree that it's not appropriate to grant a hearing on the second motion, which was heard previously. So the court will allow the referee to proceed on the issue of child support because that's properly before the referee, but the court will again vacate the referee order or notice as it relates to parenting time. And I'll ask Ms. Podolsky that you would prepare that order and submit under 7-day notice.
Yes, I will do that. Thank you.
Okay, thank you. The court will hear this matter at 9:16 a.m. The court will note the appearance of Ms. Thomas on behalf of the plaintiff, Mr. Schaefer on behalf of the defendant. This matter is before the court on the plaintiff's objection to entry of the case scheduling order following referee motion hearing. In this matter, the referee had scheduled an in-person interview of the child, presumably for purposes of the only matter that would be before the referee is that of parenting time. I'm a little bit confused, Ms. Thomas, in that you are arguing in this matter that a substantial amount of your objection argues the Vadvarka. We're not talking a change in custody. We're talking a change in parenting time.
Right, Your Honor, and I acknowledge that. And the reason I brought up Vadvarka is because Vadvarka allows the court to do the in-camera session about where does the child want to live. This isn't about custody. It's about parenting time. So it's not about where the child wants to live. So it should not be an in-camera session with the child, because the only thing that the court has the ability to do is to get the child's preference about where they reside. And to have an in-camera interview with a child when custody is not the case, that's the whole point. Vadvarka gives you all this stuff. This isn't under Vadvarka because it's not about custody. So because it's not about custody, it's also, there's no in-camera interview. That's the whole point. We don't think the child should be put through an in-camera, not that we're afraid what the child might say, that has nothing to do with it. It's why should we put the child through an in-camera interview when in fact the issue is not custody and their preference of where they reside is not applicable.
Okay.
That's the whole basis.
Maybe Mr. Schaefer can enlighten us. Why would the court do that, Mr. Schaefer?
Well, I was not there, and at the time, obviously, this was improper on both sides at the time. Apparently, the part of the allegations in the petition was that the child or the children want more time with their dad. So I I assumed that the referee wanted to have some input from the children as to how that relationship was going, whether or not that was in the best interest of the minor children, having their input as to that preference. That's my assumption of why the referee has done that. And I guess that's the only response I can say, because I was not there at the time.
Okay, thank you. Well, the court does note, as Ms. Thomas has stated, that interviewing children for a preference for parenting time is not proper, and there is no Court of Appeals or Supreme Court decision that would sanction or approve of that. As a result, the court will cancel any in-person interview, as it's not proper for purposes of parenting time. But the court will allow the matter to proceed on the evidentiary hearing on the parenting time issue, but not with any child interview. So, Ms. Thomas, you can prepare that order and submit under 7-day notice of entry. Court will conclude this matter at 9:20 a.m. Court will note the appearance of Mr. Schaefer on behalf of the plaintiff. This is before the court on the plaintiff's motion for adjustment of parenting time relief or to the parenting time. In this matter, the court does note the matter was scheduled for 9 o'clock. It is now 9:21 a.m. The defendant has not appeared, nor has the defendant filed any pleadings in this matter. The court does note, as brought up by Mr. Schaefer, that the defendant's sister is employed by Avalon Behavioral Health, which would appear to raise an issue of potential conflict. So what the court will order, Mr. Schaefer, is that the parties agree to another counselor, and that counselor would be picked by someone that would, again, participate with VA community care program, so that the parties don't have to incur that cost. And so what I'll do is you can submit an order under 7-day for that purpose and state that, again, the parties would pick another counselor within 7 days of the entry of that order. And then
Your Honor, the difficulty with that is that the other side will not communicate with my client. He had reached out a number of times to the mother of the child to get Avalon in order, and gets no response at all. So I anticipate that's what he will do.
why don't we do this, is give her an additional, let's say 10 days then from the date of that order, that she can submit to you names of other counselors that she would like that would, again, participate in the VA community care program. And let's say upon her failing to do that, then your client would be able to pick the counselor, and that would be the person that the children would or the child would participate with.
Okay, very good. I will prepare that order on
We'll note the
Sunday.
appearance of Mr. Mr. Todd on behalf of the plaintiff in this matter. Defendant has not represented, has not appeared in this matter. The case is before the court on the plaintiff's motion for revocation of acknowledgement of paternity. I do note Mr. Todd has included in his pleadings the DNA test report for Mr. Wood. It shows a probability of paternity of 99.9999996%. Court does believe that you've met obviously the burden to get an evidentiary hearing. So the court will simply direct Mr. Todd that you would contact my office and see when you're available, and we could do it on a Wednesday. And hopefully we would be able to have Mr. Terrell present, or Mr. Wood, or somebody else present as well. I guess you don't have any control over that.
Yeah, well, I think we have contact with Mr. Wood, so.
Okay, fine, thank you. And we will then see you at the time that we are able to set that Wednesday hearing up.
Great,
Good
thank you,
morning
Honor.
to Thank you.
Good
morning.
morning.
Thank
you.
Court will note the appearance of Mr. Schaefer on behalf of the plaintiff, Ms. Elaine on behalf of the defendant. This matter is before the court on the plaintiff's notice for entry of order following hearing. Ms. Elaine has objected, Mr. Schaefer, saying that both of your orders are wrong. And why don't you respond?
Okay, and that's the reason I've noticed both of these up, Your Honor. As you noticed, there are two orders stemming from March of 23 and May of 23. We have been unable to come to accord on the language. So they need to be entered to effectuate a lot of things, including the amount of support that has been not complied with without any order being in effect. I believe that they are accurate based on Your Honor's rulings, and the one in relation to Your Honor's rulings after it had been objected to the first time. So I'm submitting to you that I think they're accurate from your rulings, and I'm asking that to be entered.
Okay. Now, Ms. Elaine does state that, again, because the court had referenced in the finding in this matter that it would, and I use that by analogy, it shouldn't apply in instances where it was, let's say, going to be less than an hour because of the transportation issue. So now she states that we could, I guess she doesn't have an objection if we state that it would not be applicable, or he couldn't have that parenting time if it was less than an hour in the morning, but in the afternoon, where again, she may be working and it'd be more than an hour, you would put in there that simply that it would be limited, to the transportation of the children, but court didn't order that it was limited to transportation, that again, that it was during the times that she was working. So why would that not be appropriate to just state that, he has a right to have the children at times she's working, except if it's a period of, let's say, an hour or less?
I think that would probably be consistent with Your Honor's ruling, along with the other language that I had in my order. I would have no objection to placing it in there.
Okay, Ms. Elaine, then that apparently addresses your objection. Is that correct?
Well, I'm a little unclear on what opposing counsel just said. He said, as long as my other language is included. So as I suggested, I believe that his paragraph should be stricken and just that one sentence it should be replaced with.
Okay, then the court would in fact order and to clarify that again in the morning that it's that the parenting time would be if in fact the children would not be available for more than an hour, that he wouldn't have that particular parenting time.
Less than an hour.
Excuse me?
Less than an hour.
Yes.
Yes.
If it's an hour or less.
Yes.
That he wouldn't have that parenting time, but
Right.
otherwise he would have the parenting time at times that she's working. If it's over that hour, and the court, additionally, there was the issue concerning the child support. The court would allow the deductions as, I guess you say, is calculated by the referee. So I'm not going to open it up to any other deductions. No. I think those were appropriate.
Right, Your Honor. And I don't think we're arguing that, at least I'm not arguing that whatever the referee did with Ms. Tabaka's income should be changed. No one objected to that, and no one, there was no ruling to the contrary. But I think I did find in going through opposing counsel's calculations and comparing just the Alexis Tabaka column with the referee's column, I do think I found the error in opposing counsel's, which resulted in that, whatever it was, $12 difference. And I can show you if you'd like.
No, I saw your pleadings. All I'm saying is that the referee's deductions were appropriate and the court will utilize those.
Right. But I think we're both utilizing them, but still coming out with different numbers. But it's because opposing counsel is starting out with the wrong base income for Alexis. I can show you really quick if you want.
Well, go ahead and mention what it is, Ms. Elaine.
All right. Thank you, Your Honor. If I could just have my screen share enabled, I have it all up and highlighted for you.
Okay.
Sure. Still blocking me. Oh, here we go.
Ms.
Okay,
Lane, you sure Mr. Schaefer doesn't have control of that screen share?
I'm not sure of that at all. Let me do this here. Okay, so on the left-hand side is Mr. Schaefer's. And if you can see here, he starts out with a total monthly gross income of $41,9507 for Ms. Tabaka. On the right is the referee's, and he starts out with a total monthly gross income of $45,1024. And you can see at the end, after all the deductions and such are taken, which I believe both of us inputted correctly, and the same as the referee, Mr. Schaefer's ending up with $26.39 for her net, and the referee ended up with $26.69, and that makes that $12 difference in the end. So what I used are the numbers the referee used, and Mr.
Okay.
Schaefer did not.
Mr. Schaefer, what's the discrepancy?
I don't necessarily agree with her analysis of what was used or not used. I think Your Honor ruled that it was the numbers that the referee determined for your order. I will go back and check it. I'm not sure that screenshot convinces me any more than what we had talked about before, but I will recheck.
Well, what happened is the court had previously stated the court was going to use the referee's numbers, so I used the referee's numbers. I don't know what the discrepancy is or how it is. I'm just using the referee's numbers, so use the referee's numbers, and that will give us the correct amount then.
Your
Okay,
Honor, will
very
you
good.
please enter the uniform child support order that I attached that uses the referee's numbers, because Mr. Schaefer's does not.
Okay.
I disagree, Your Honor.
Your Honor, one of the issues I have and why it's a little irritating that we're here today is that I asked Mr. Schaefer specifically to show me his discrepancy, my discrepancy, show me where I was wrong, and he just never responded. So
in all
even
due
as we sit
respect,
here today, I don't know what he claims the right number should be vis-a-vis
we
what the
have-
referee did.
I've responded numerous times. The response is not what she wants to hear. And so that's why I noticed it up.
That's not
Okay.
true.
Well, the court will, again, it does look like there's some difference, but I don't know what is causing the discrepancy, but the court has stated we'll use the referee's numbers. So if we're using the referee's numbers, we should end up with the referee's amount. And if that's included, I will give you time to Mr. Schaefer to review Miss Elaine's numbers. Miss Elaine, if you would just renotice your UCSO up under 7 days. And unless Mr. Schaefer comes up with something substantial or showing how again, it doesn't comply with the referees, my intent would be to order it and enter it at that time.
I did show him all of that back in June.
I understand, but he's noticing up his order, and we'll notice up yours as well, so that we get them at the same time, and we'll get them entered. So thank you. Court will conclude this matter at 9:39 a.m. Be free to go. Have a good day. Hearing in
Thank you.
pro per. Matters before the court on the plaintiff's motion for custody, parenting time, and support. I guess one thing we have to resolve, Ms. Huffman, I note in looking at your pleadings that your client resides in Branch County, and it looks like the defendant lives in Indiana, and that all of your pleadings after the initial complaint have an Indiana address. She was served in Indiana. So the court would infer from that she lives in Indiana.
Yes, that's my understanding, is that she is in Indiana now. She was not at the time that we filed. She actually did live in Calhoun County. Although she was served in Indiana, she still did live in Calhoun County. She was just working at McDonald's in Indiana. And I believe that just because she moved since she was served doesn't mean that we don't still have jurisdiction in Calhoun County.
Well, let me check with her and see. Miss Marshall, at the time that the action was filed, were you residing in Calhoun County, or were you residing in Indiana?
At the time I lived in Calhoun County, yes.
Okay. Well, that resolves the issue of jurisdiction then. Ms. Marshall, it's my understanding you had a request or something. Is that correct?
Yes, for this court date today, I am requesting to get it postponed because as of right now, there is a pending abuse case against Alec that is open right now
Okay.
with CPS.
Okay. Okay. Well, again, on that basis, the court the court will not put the matter over simply because somebody has made a complaint. We have no idea if there's any credibility or justification for the complaint. Anybody can call and make a complaint. So I'm not going to delay this matter simply because a complaint's been made. So go ahead, Ms. Hoffman.
So I would just ask that this order be entered. That's all. It was just it was a 7-day order. Originally, I missed the date by 1 day due to 4th of July. 4th of July landed on Tuesday, I believe, and I think we were out on Monday and filed it on Wednesday, so we missed it by 1 day. The court denied that due to the 1 day we missed, and so we just are asking it to enter by notice of the hearing today.
Okay, Ms. Marshall, what's your response to the order?
I'm sorry, what was that?
What's your response to the submission of the order? Well, you received an order.
Yes, I have it in front of me.
Okay, well, I'm saying, do you have any response?
As far as, I mean, the 50-50 thing goes, I don't really agree with that.
Okay. Well, then you're gonna have to file appropriate pleadings in this particular matter. But at this point, the matter is scheduled before the court today. The court is going to enter that particular order, and you'll need to file a motion or other pleadings in this matter to again have the court to review that at some future point. But at this point, the court is going to enter the order. So. Court will end this matter at 10:05 a.m. You're free to go. Have a good day. Both of you.
Your Honor.
Court will note the appearance of Mr. Todd on behalf of the plaintiff, Mr. Brueggemann on behalf of the defendant. This matter is before the court on the defendant's motion to hold proceedings in person. Mr. Brueggemann, I've reviewed your motion in this particular matter. You've stated that holding the evidentiary hearing in this matter in person would help the counsel, the parties, and the court all understand one another as evidence is presented in the court, and also under paragraph 6 to assess credibility. Is there anything else?
No, Your Honor, those are the, I think, key parts of this.
Okay. Mr. Todd, what's your response?
Your Honor, I would just leave it up to the court's discretion. I don't have a position either way, to be honest.
Okay, thank you. Well, the court would note that since COVID and since after that, we've been doing things virtually. The court's heard hundreds and hundreds of cases, which we've done by video. The court doesn't find that, again, that impacts substantially on assessing credibility. In fact, it might make it somewhat easier as parties are more inclined in their, let's say from their living room or that, to be more relaxed and more open. And so I found that the people are far more likely to, again, demonstrate their true nature in these particular matters as it relates to holding a hearing just to help parties and court understand. I think that's clearly that the court can do that. And as we've said, we've done that. The court would note that the motion does not address the factors under Michigan Court Rule 2.407 C. And as a result, the court is going to deny the motion. And I'll ask Mr. Todd that you would prepare an order denying the motion submitted under 7-day notice of entry. The
Okay.
court will note
Thank
the
you.
appearance of the defendant in this matter. The plaintiff has not appeared. It is now 10:41. We waited some time to see if she would appear. She has not. The matter is before the court on the defendant's motion to set aside referee recommendation in this matter. Sir, you did put in your objection. You said that there are issues that the court needs to investigate. I will tell you the court does not investigate. The parties bring all the matters before the court. The court simply decides what the issues are.
Oh, okay, sir.
I do note that you said that the child has been with you for the last 8 months.
Yes, sir.
And that's of concern. So what I'm going to do, I do note as well, you stated you attempted to join, but you had some difficulties or you couldn't join.
Yes, sir.
I'm going to refer the matter back to the referee for some supplemental proceedings. And you'll have an opportunity at that time to present whatever it is you want to present. And then the referee can consider that as it relates. If the referee chooses to then change and reconsider his ruling, he's entitled to do so. If he doesn't, then he wouldn't at that point. So
Yes, sir.
or at least allow you to present whatever evidence you have.
Yes, sir.
Okay.
Yes, sir.
So that's what we're going to do today. We'll conclude at 10:42 a.m. and we will enter an order, and then you should be contacted
Attorney
within
Paul
a
Unlove
week
for
or so.
plaintiff and attorney Nancy Kirkpatrick for defendant.
Okay. Good afternoon to all of you. I'll go with you first, Mr. Umloff, as you represent plaintiff. Tell me what's happening in the case.
Your Honor, we mediated this case a couple of weeks ago. We did not reach a settlement. I think at this point we will need to have a trial.
Okay. Ms. Kirkpatrick, is that your understanding as well?
It is, Your Honor. We mediated with Mr. Brundage. I think he gave us, good service in the mediation, but we did not settle any issues.
Okay. Well, that's unusual for Mr. Brundage not to settle some issues, but
Yep.
So be it. What we'll do is, what are you looking trial-wise? How many days do you think we're going to have to try it?
I think one would be sufficient. There are a lot of issues.
Okay.
I do too. I think that 1 day should be sufficient.
Okay. What we'll probably do is I'll probably put you on for at least a day and then probably a backup another half. Only because I don't know where you're going to be, and with the court having to give a ruling, it may take some more time if we only finish proofs in the first day. So we'll give you a date, and obviously, if we conclude in 1 day, then fine. But otherwise, we'll have the backup date as well. So we will contact both your offices to see when you're available and when we can get the matter scheduled.
Thank you, Your Honor.
Okay.
Thank you.
Thank you. And court will end this matter at 1:48 p.m. You're free to go. Have a good day.
Thank you.